We're going to drag Inslee in the district court. We're going to drag Inslee into circuit court. And if we have to, we're going to drag this tyrant and this assault weapons ban before the United States Supreme Court. Watch this video, guys, for all the latest and take action. Hey guys, Aaron Dorr here with Washington Gun Rights with an important legal update for our members and other gun owners who want to know where are we in the process of dragging Jay Inslee into federal court and challenging his recently signed assault weapons ban. So I'm going to kind of break down where we are in this process and give you guys some context and hopefully a real reason for encouragement as we work to invalidate this tyrannical BS in federal court. So kind of a brief overview on where things stand. HB 1240, as everyone knows, has been signed into law. It is now a crime to buy an AR-15 or any one of 62 other specifically mentioned long guns that were listed off in the bill. Certain kinds of handguns have now been deemed assault weapons as well. And in general, it is a complete ban on modern firearms for gun owners here in Washington state. What you may or may not know is the bill also makes it a crime to buy parts to maintain or keep operational quote-unquote assault weapons that you currently legally own. So if your AR-15 needs a new barrel because you've shot it out, it'd be a crime to replace it. If you need to have a spring in your upper receiver or lower receiver, it'd be a crime to replace it. This is an absolute assault on your Second Amendment freedoms. And obviously, with Jay Inslee in the governor's mansion and his psychos running the chambers in the state capitol, there is no legislative component to fixing this problem. A violation of this, just to be clear, is a gross misdemeanor and a $5,000 fine for just the first offense. So, of course, none of this stops crime. None of this stops criminals. It's all designed to make criminals out of law-abiding gun owners like you and me. Now, there's 4 or 5, in fact, even 6 or 7 now, various lawsuits that have been filed against this assault weapons ban. WGR is about to file our amicus brief on one or maybe even multiple of these various lawsuits, and our legal team needs your help, guys, to finish this up. So hit the link below and donate and help WGR fight back with our amicus briefs before it's too late. We're going to give all of you a copy of this amicus brief when it's all said and done, so you can see exactly how your support is being used here at Washington Gun Rights. So that's all coming in the very, very near future. Now, a lot of people have kind of asked us, is there any point in trying? A lot of you have said, the Ninth Circuit is where freedom goes to die, that our chances of overturning this have got to be very small. And what is the point in even trying? Guys, that was right in the past. My entire life, my entire childhood growing up, the Ninth Circuit's where freedom always went to die. It was the most anti-gun circuit in the country. They were liberal AF. Everything they touched, they turned to dust and ashes, and it was a wasteland for freedom and anybody who cared about what was good, right, and proper in this state, in this country. But that is not the same anymore. President Trump, love him or hate him, put 10 justices out of 29 on this court during his 4 years in the White House. And that has completely reshaped the partisan nature of the Ninth Circuit. And so if you're asking why are we discussing the Ninth, because we assume off the get-go that we're going to lose in federal court at the lower district court level. That should be everybody's assumption. That should be everybody's assumption. The real fight here is to get before the circuit court, the Ninth Circuit. And so here's a map of the Ninth Circuit. This is what we're talking about. It is the largest circuit court in the country. Again, it has 29 justices, but President Trump named 10 of the current 29. And so while it was a horrific circuit, the most liberal in America for most of my entire adult lifetime, my entire lifetime, it is no longer the case. And so we have a very real chance of seeing this overturned. Here's an example. Go back to this map here. In California, San Diego, the district court judge in San Diego, his name is Judge Benitez. Just in case you don't know this, the judge has already ruled last spring that California's assault weapons ban was unconstitutional. Now, California, of course, appealed that, just like we would see happen if we were to win at the district court level here in Washington state. But then that was before the Bruen decision came down last June. And so this is Judge Benitez before Bruen came down saying that California's AW ban was BS. That was appealed, and the Ninth Circuit, rather than taking the case on, gave it back to Judge Benitez and said, reissue your decision on the constitutionality of California's assault weapons ban, so-called, in light of Bruen. Now, follow me on this. If Judge Benitez said that California's AW ban was BS before Bruen, it certainly stands to reason he's going to have even more aggressive arguments after Bruen. And so what we have right now in our own circuit is another federal judge who has said that a nearby state's assault weapons ban is BS. And that's going to give us a lot of ammo to use as these various lawsuits make their way through the process here in Washington state. So there's a very real reason to hope for gun owners as this process goes forward. Just a brief overview on that process. We have the federal district court. Then you have the federal circuit court, the Ninth Circuit in our case. Then you have the Supreme Court. I can just tell you right now, it seems as though our assault weapons ban, the one that passed in Illinois this year, California's AW ban, maybe even New York's AW ban, all of these states seem to be heading to the Supreme Court for adjudication. And everyone knows that the Bruen decision from last year kicked the doors off of the what was previously considered the way that gun control laws were examined. Prior to Bruen last year, gun control laws had to be examined based on their history and their text. That was the two-pronged approach used by the courts. But as you guys probably know, Clarence Thomas rewrote that playbook, and he added a third prong to that, which is the historical use of firearms in this country. And so going forward, all future and ongoing gun control laws, including the one that was passed here in Washington very recently, they have to show, the AG Ferguson has to show how it is historically accurate that America banned its citizens from owning modern rifles. We have, for the first time in our lifetime, a very real chance of not only seeing circuit courts uphold our constitutional right to own an AR-15, there's a very real chance we'll see the Supreme Court uphold that same right as well in the wake of last year's Bruen decision. Now, timeline on this, no one can give you that. No one can give you that. We have to go to circuit court first. We have to go to district court first, then circuit court, and then the Supreme Court. That's how that process plays out. It's going to take time. There's no question about it. There's not going to be immediate relief for gun owners. Now, there might be an injunction that is granted by the district court judge against this current law, which would give immediate relief, but we're not going to hold our breath on that. So, guys, there's a lot of pieces moving on this. WGR is leading the fight. We're going to have an amicus brief ready to go for you guys to read very, very shortly, but we need your help to get that done. So, again, hit the link below. Donate today. Help us fight for you guys in court. We'll have this done for you guys shortly. Let you guys read this very shortly and be in touch, guys, with more information as soon as we can. Thank you very much, and share this video.